I'm going to shift now to talking about claims procedural issues. So throughout this presentation, you've heard us say file a claim, file an application, lodge an appeal. Now we're going to specifically break down what that actually looks like, where it happens, and what it means. So the VA over, as long as recent memory serves, has been in a lot of hot water with the media for their practices on the healthcare side of things, right, where they were creating huge and unnecessary delays for veterans to receive healthcare treatment. Some of you might remember a couple of years ago, it's actually Jon Stewart on The Daily Show when he was hosting that program, did a story about the tremendous wait times that veterans were experiencing in applying for benefits. Does that ring a bell for folks? Okay, yeah. It was quite scathing, to say the least. What we're going to be talking about next refers exactly to that very system. And so I'm going to weave into the discourse here a little bit about the controversy and where it happened, where the actors are, and what the VA has done. And I'm going to spend a particular amount of time emphasizing the first two parts of the appeals process here, and that's the claim filed at a regional office and an appeal at the Board of Veterans Claims. The other two sections I'm going to speed through a little bit quickly, simply for the sake of time, one, and because it is unlikely that you will be in those ranges for your particular cases. So without further ado, let's jump in. So there are three types of claims that can be filed at a regional office. They're all listed here: a new claim, a reopened, and a clear and unmistakable error claim. A new claim breaks down into a few different forms. We'll go into each one of those in more detail. A reopened claim pertains to at least one of the cases that you're going to be working on here on behalf of the Vietnam veteran. That means a claim that has been filed before, but the appeals period has lapsed, and they need to file a motion to reopen. And a Q claim is an entirely different beast altogether. So why does the different types of claim matter? When does the file matter? So much of VA practice and so much of what the veteran will ultimately be compensated for depends on when they have filed, what we call the effective date. And that is because, as Jon Stewart unfortunately highlighted, the delays are so long that by the time these cases are often granted, the effective date might have been 2 years ago when we filed, and the veteran is due benefits from that date forward, right? So that could be a significant pay in retros. In our practice, that is sometimes, upwards of $100,000 for these particular veterans, and that is life-changing money. So I'm gonna talk more about each one of these things, and please jump in with questions here. So around the time that the big controversy broke, the VA was operating in a set of what we're going to refer to as old rules for shorthand here. The claims did not need to be very formal. In fact, there was a very low standard on what they even needed to contain. I'll show you more of that. And all of the claims filed before March 24th of 2015 are grandfathered into those old rules. So we're talking about both sets here because chances are you will have veterans who might have applied or have feet in both sets of rules, okay? New rules, a lot more restrictions on what constitutes a claim. So much more formal, looks like, certainly not to the level of civil litigation, but they're much more specific and will kick forms back to you if you don't do them correctly, as we have learned. So prior to March of 2015, there's two of the primary sets from the Code of Federal Regulations, the definition of a claim. It basically breaks down to an indication of an intent to file and identification of the benefits sought. So that could be an oral communication from the veteran. So if a veteran walked into one of the 54 regional offices that are kind of the first place that claims land for VA benefits and said, I am a veteran, I intend to apply for benefits related to my back injury, and then walked out, and one of the public contact team members of the VA happened to turn around and document that, intent and identification, that documentation would have counted as the beginning of a claim. The rules were quite forgiving to veterans. The idea was most people in this, and it was true, and actually it's still true, are pro-per litigants, right? They're probably not going to be able to satisfy all of the, crossing of the T's and dotting of I's that are required for traditional filings. So could also have been a medical report, wide range of things that could constitute that initial claim, that first inkling of an effective date, right? So identification of the benefits sought. These slides in here are meant to be referential, so I'm going to go through them, but know they're here if you want to come back to them as you're working through your claims. Used to preserve an effective date. Again, I'm going to skip to this next one here. So the new rules, though, came along and changed what was otherwise a pretty forgiving system for pro per litigants. The VA implemented an intent to file form. So now it must be on this specific form when a veteran wants to file a claim. They will no longer accept any of those more loose formats. So if we sent off some medical records to the VA with nothing else attached to them, we would get a letter kicked back to us that said, with this form attached to it, saying fill this out before we can start really actively working on a claim. Okay. Now, in this next section, I want to talk about a particular procedural step, the reopens, that will apply certainly to case number 1, and I believe case number 2 as well. Many veterans, due to the complexity and challenges of their lives, might file a claim at some point. Maybe they've come into contact with another community advocate or another veteran who helped them fill this out. But because of everything that's going on and just getting to basics that they're dealing with every day, they may miss an appeal window, right? And it should be added, most of these cases do need to be appealed. The VA's general denial rate is about 80% for claims. So a lot of folks are going to be in some appeal phase in the future, and we really see that bearing out in the cases we see coming to our doors in our community legal clinics. So the effective date for the reopen is the filing of the reopen, not the initial date when the veteran filed their first claim where the appeal period lapsed, right? So even if you are ultimately successful in the reopen claim, it will not reach back in time to the maybe many years beforehand. So let me talk through the requirements to file a reopen, because it's a little different than the new and informal claims that I mentioned earlier. So there's a threshold determination. A veteran must present new and material evidence. New, self-explanatory, but material, meaning evidence that relates to unestablished facts in the claim that are necessary to substantiate it. So where the claim was faulty beforehand, right? Maybe there wasn't sufficient evidence to show a nexus. Maybe there wasn't sufficient evidence to show an event in service. That's a very common one. The claim will need to be rehabbed on those grounds with new evidence for the VA to consider it again. When that threshold is met, when new material is met, the VA will review all of the documents in the claims folder again. So everything previous. You don't just have to kind of redo the claim with new evidence completely, just on that one element. So that is helpful. That is helpful. Let's see here. This is generally a pretty easy standard to meet. So veterans come to us concerned. You might hear that in some of your cases that they missed an appeal date. That's okay. Through this device, we can reopen it, although it certainly will not reach back in time. The one difficult way that you can reach back and touch that earlier effective date from the claims is something called a Q claim, or a clear and unmistakable error.
And if you want to reach back, is so that we can get more benefits?
That's right, so you can get more money, have an earlier effective date. That's right. Now, given the stakes, these are much harder to establish. So I've put some of the basic rules out here. So, the VA adjudicator incorrectly applied the laws and regulations. So that happens a lot. So that may not be the hardest part of this to achieve, but it's really the next two, or the next one that gets you. Error occurred based on the record and the logs at the time, and the error must be outcome determinative. And it must be, point 2 is really what we consider the freeze frame requirement. That means the claim must have been able to have been granted on the evidence in the record at that time. So if the veteran filed something in 1992 and we're trying to establish a Q claim, we can only look at the evidence that was in the file at 1992. We cannot amend or use additional evidence, right? So many folks, like I mentioned, are going through the system on their own. They may not fully know where that claim was deficient before, or they didn't meet the standard, And even if we can see that they clearly do based on additional evidence in 2017, it is not going to be sufficient to go back. It has to have been from that 1992 claims file, everything that was contained. So that is often the requirement that just knocks out so many Q claims. More often than not, we are using the reopen device if a veteran has filed and an appeal period has lapsed. And I think that in the cases we have presented here to you today, the reopen will be the device that we recommend using, unless you uncover more significant evidence in your discovery periods with the claims. So as I mentioned, it goes back, potential for huge retro awards here, and you can imagine why, right? If a veteran is granted today from a claim that was filed initially in 1976, it could be millions of dollars. Great. So what happens? A veteran files a reopen or they file a new claim. What does the VA do? That lands on the desk. Where does it go? So it lands on the desk of one of 54 regional offices across the country, and the VA then enters what's called a development period. So they're going to look at the materials of the claim, or at least in theory, they should be looking at the things that you sent to them, and they may order what's called a compensation and pension examination, where they have another doctor who's paid for by the VA review everything, maybe do an examination of the veteran and get their opinion. You may be unsurprised to learn that that opinion often skews against the veteran. Very frustrating. They may ask for more information from the veteran, records from service, more medical records. Maybe the veteran has gotten treatment at a private facility, something like that. The VA will notify you or the veteran of that request through what's called a VCAA notice, or a Veterans Claims Assistance Act notice. Well, they'll say, we want to see this, or send us more information if you have it. They'll trigger you. It's an important, just kind of practical thing. I always tell the veterans we work with, if you receive anything in the mail from the VA, call me right away, because they don't always copy the attorney, even though they're supposed to. And that often happens on these particular notices from the VA, the Veterans Claims Assistance Act notices.
Even if you make it clear a person's homeless and may not have access to a proper mailbox.
Yeah, sadly, yes. Sadly, yes. Go ahead.
Important clarification there, too. If in that scenario, oftentimes if the veteran's okay with it, we will actually include our address as his or her address to anticipate exactly what it is you're presenting.
Yeah, it's a great point. So the VA does have a duty to make possible all efforts to collect service records and these records on its own. Unfortunately, this particular duty, although it is in the regulations, has no enforcement mechanism. So there's not a way we can say, hey, VA, you failed in your duty, and here are the consequences to that. We can point out that they failed in their duty, but there isn't really some sort of enforcement or punishment to that. They'll say, okay, we failed. We're still going to deny the claim. There's not really any sort of teeth, and so we often don't even raise this as an argument, even when we see it clearly. After the development period, the VA will issue an initial ratings decision. It's like the first decisional document you will see from the VA in the case. It's the first indicator you get from them of what they're going to do. Hopefully, they grant it, and everyone goes home happy. But oftentimes, we're seeing in there with the 80% denial rate what the VA is thinking as to why a claim should be denied. So it's a very helpful document for us as advocates to know exactly where we need to beef up these claims on which elements. The veteran, if they're issued a ratings decision and it is negative or a denial of their claims, they have 1 year from the date of that mailing from the date on the ratings decision to appeal. The point of appeal with the next document the veteran lodges is called a notice of disagreement. At this point, though, they also have the option. They also have the option of requesting a review by a decision review officer, which we recommend. It gets it before an informal hearing officer of sorts at the VA. There is a form for a notice of disagreement, much like there is a form for the new claims that come in. They're all available on the VA website in fillable PDFs. So after receiving the notice of disagreement from the veteran, that's often supplemented by us with additional materials as to why we think the claim should actually be granted. The VA then will issue a second decisional document called a statement of the case. This is, again, all still happening at those regional offices, all still happening there. In the statement of the case, the VA will either double down on its first decision or they will change its mind. And they could issue benefits at that point. The record remains open throughout this entire thing. A veteran can submit new evidence at any time. We tend to recommend that those submissions of new evidence happen in big, distinct chunks, right? At the filing of a reopen, at the filing of a notice of disagreement, because otherwise the VA is like maybe about to make a decision, they get new paperwork, they have to review that, and it causes a further delay. So we're going to recommend to you all that gather everything, then submit as much as that's humanly possible. If for some reason new evidence comes into play after a statement of case is issued, the VA can review that evidence and then issue a supplemental statement of the case, a third decisional document coming out of the regional office, reviewing that evidence and seeing if it changes their mind or not. So fortunately, if a veteran still disagrees, then they can file what's called Form 9 and get out of the regional offices into the last arbiter of the administrative appeals process, known as the Board of Veterans' Appeals. So that must be filed within 60 days of the final mailing of the statement of the case. And then the regional office will transfer jurisdiction of that claim to the Board of Veterans' Appeals, which sits in Washington, D.C. So some quick, did I hear a question? No? Some quick facts about the Board of Veterans' Appeals. Most of our cases do not go to this level. I'm not going to spend a ton of time talking about it. And I'm also going to tell you why they don't go to this level in this next slide. 7 years, 7-year wait time and going up right now for a veteran's case to be heard at the Board of Veterans' Appeals, right? So you can imagine what that means for our clients, right? We are trying and very much hedging our bets to win these cases at the lower levels of appeals at the regional office. We are exercising every right to submit new evidence, every decision review officer hearing that we can to try to avoid this incredibly lengthy and unjust time for these cases to be heard at the Board of Veterans' Appeals. The reason this wait is so long, and has actually grown significantly over the last couple of years, is when the VA was getting so much bad press about the initial wait, the time that veterans were incurring filing even initial claims, they shifted a lot of their resources into regional offices and away from the upper levels of appeal at the BVA. So that's all fine and good, but what happened was that a lot of that staff was not well trained. And so they made all sorts of errors that were appealable, and the cases got bottlenecked here, right? A series of very tragic errors where veterans in our communities are the ones who are really feeling that most acutely. So I am going to fly through these next couple of slides, and we're going to shift, yeah. Yeah.
So based on that 80% denial rate, what is the chances of that being overturned? Are there statistics on how often that's overturned?
If they're represented by an attorney, that's just significantly more likely that they will be overturned. I believe, it depends on the study you look at, and there's, as John mentioned earlier, kind of doing a more broad sweeping study of this, but anywhere between 25 to like 75% more likely to have a claim granted. I don't know the numbers. I cannot recall exactly what it is if they're represented by maybe an advocate, or a non-attorney advocate, or as a pro per, as a veteran just going through this on their own. Yeah. It's not good. It's not good.
You should just skip that first part. Just,
Yeah, it's a mess. It's a mess. All right. So if somebody continues to disagree with the Board of Veterans' Appeals, and they're going to move into the federal district courts at the Court of Appeals for Veterans Claims, it's an Article I court. We see a lot of folks in the veteran. There's actually a private bar of people who do this practice. Most of them practice at the Court of Appeals for Veterans Claims. It has to do with the availability of ECJ fees at that level that make the work more lucrative. Let's see here. Some very practical considerations when you file a claim. Certified mail, although they're increasingly moving to a fax system, and we'll share that information with you as you get closer to your submission. I know, everyone. They have recently discovered you can move things through phone lines, so who knows what's next. I know, I was so excited about that, but I realize now it's all relative, right? So we really recommend, particularly at the lower levels to the extent we can, avoiding the legalese. Many of the people who you will be working with are not lawyers, and so things like arguing the alternative, that's not going to square well, right? You just said this, why are you saying this now? All of the evidence now that is submitted to the VA is put through scanners, and so if you put tabs on the sides of things as reference, they will be ripped off and sent through these scanners. So we'll provide sample briefs for you that show you how to build something that makes some sense and can be used as a reference tool for the person who's receiving it without having this as a problem. Again, be aware of VA errors. They happen a lot, and the best way we catch them is usually in constant contact with our clients, checking in every 30 days or so to see if they've received anything, even if we don't think we'll hear for months. It's a good tool and a good way to just stay in touch and figure out what's still happening with them. So recognizing that and I'm just going to drill through the end, is that right? All right. Recognizing that applications move more slowly, the VA did create a carve-out for homeless veterans to try to help the folks who maybe need it the most get through quickly. So homeless veterans are entitled to what's called expedited processing. You see, the citation here that allows that. I'll tell you, in practice, that does not really happen. Again, it's a regulation with no teeth, right? We cannot enforce this. So we request it, we hope for the best, we signal in every way we can, buy large red stamps sometimes that our veteran is homeless and they should expedite these applications. We recommend you do it. Its effectiveness is difficult to gauge. So ending your case and withdrawal from representation, steps are listed here. I'll let you review them as that time comes. And of course, knowing when you're done, we do ask that as your case wraps up, you check in with us. There's a few closure things we need to do on our side, including some reporting to the State Bar of your hours, amongst other things. So with that, we have gone through, and you are now all officially accredited agents to represent. That's right. And so it's a nice segue to, Elia, how we wanted to, I think, wrap up the training here, which is, I think, selecting teams, you thought, to work on the two cases. So in conclusion, thank you all so much for your time this evening. I know sitting through 3 hours of a presentation is a bit lengthy. I hope you find these helpful as you work on the cases going forward. And thank you on behalf of all of us at InterCity for your time working with our veteran clients. Your work will really make a difference in their lives and in restoring justice and dignity. So we are so appreciative. Thank you. Mm-hmm. No, thank you. Thank you.